तुम मुझे 50 मिनट्स दो, मैं तुम्हारा एटलीस्ट एक प्रिलिम्स पे क्वेश्चन सही करवा दूंगा. दिस इज व्हाट द सुप्रीम कोर्ट आर्टिकल्स in this video would talk about. You would be knowing that judiciary comes in prelims for at least 2 questions, and even in the mains for at least 1 question. And in there, the provisions which are particularly related to Supreme Court in Constitution are being reflected in the statements or in the discussion of the mains. So, and particularly the standard sources do not talk about the details of the provisions which exist in the Constitution, particularly with respect to Supreme Court. So my intention behind coming up with this video is I want you to like clear all the confusions. I want you to know, understand, and actually internalize few of the nuances that exist with respect to Supreme Court. And most importantly, I want you to get those low-hanging marks which existed. To begin with, Supreme Court in itself is reflected in Article 124 to 147 in the Constitution, and every article from this discussion is actually very relevant because from each article, particularly the questions are being asked. Sometimes they ask particular questions from, let's say, Article 136, 142, 145, 129, but also minor articles like 139 also minor articles like 134 also. In that case, it becomes very pertinent, very important to actually go a bit in detail, a bit depth to the bare acts and see what kind of articles are exist with respect to Supreme Court. And so via this video, via my like efforts, you would be thorough with any discussion, any statements, any nuances that will exist with respect to Supreme Court. The article, to begin with, the Article 124 talks about the establishment of Supreme Court of India, and it was established on the 28th Jan of 1950, and it replaced the Federal Court, which was constituted under Government of India Act 1935. Even though like this act never came into picture because the federation could not establish, because the states were there, but the princely states did not join in. But still, the provision you should know, and it seeks to establish a Supreme Court of India with Chief Justice of India and other judges. The number of other judges would be determined by the Parliament. Remember, this is a very crucial fact, and you should know that Parliament determines number of puissant judges. Puissant means subordinate, or puissant means other than Chief Justice of India judges. They are determined by the Parliament. And second thing is, all the judges of Supreme Court are actually appointed by the President. And with respect to the appointment of the judges of Supreme Court by the President, there exists a clause that the judges of Supreme Court are appointed by the President after the consultation with such judges of Supreme Court and High Court. And here, the word of consultation and such judges of Supreme Court and High Court has been clarified through the 4 cases. Initially, there are 3 cases, but one case of NJSC became quite prominent, and it was asked in prelims also. The 3 judges cases, in the first judges case, it was held that the consultation, the meaning, the word of the consultation means merely the exchange of views. Then in the second judges case, it means that it's not merely the exchange of views, but the views are binding, and consultation means concurrence. However, in the third judges cases, it was expanded to concurrence of the plurality, so which led to like establishment of the collegium system that exists in the current state, whereby 4 senior most judges of Supreme Court are consulted by the CJI. Also, there was a constitutional amendment bill which was struck down by the Supreme Court, called as National Judicial Appointments Commission, which actually seeks to establish a formal arrangement between the judiciary and the executive for this consultation processes. However, that was held unconstitutional within the purview of that it seeks to destroy the basic structure, and it takes away the independence of the judiciary. However, you should know that the discussion around reopening of the case of NJC has been in question with respect to like Justice Suryakant actually talking about it. Next is, President cannot appoint any judge to the Supreme Court of India. There exists a qualification, and the qualification itself is given in Article 124 Clause 3. It says that a judge For a person to be appointed as judge, it must be a citizen of India. Firstly, of course, it must be there, and secondly, it must be a judge of High Court for 5 years or High Courts in succession. So I mean, he can be of like High Court of Delhi and for 2 years, and then High Court of Bombay for a few years, and then High Court of Allahabad for 1 year. It's also all right. And then, or he or she can be an advocate of High Court for 10 years. And most importantly, the very peculiar clause that exists here is a person who is a distinguished jurist in the opinion of president can also be appointed as a judge of Supreme Court. And all of these appointments should be done with the collegium system in consultation with the Chief Justice of India. Now, you should know that Article 124 Clause 3 talks about the removal of judges as well. So they are given the security of tenure. Security of tenure means that they can only be removed on the basis and on the process which is being given and established in the Constitution itself. And generally they hold office till the 65 years of age, but before this they can actually be removed by the process which is given in the Constitution, and only on the grounds which are given in the Constitution. The grounds are proven misbehavior or incapacity. Only these grounds can actually lead to the removal of the judges of Supreme Court. However, the removal is done by the president, and president can only issue such removal order when she receives an order or an address by the parliament which was passed by the special majority which seeks to remove such judge. Let me put it again. 124 Clause 3 actually talks about the process about the removal of the judges of Supreme Court, and the two grounds are given there. First is proven misbehavior, second is incapacity, and only on that basis, if the parliament found them the guilty of such charges, then they will pass a address to the president for the removal of the said judge, and the address must be passed by the special majority, and only after that president will issue the notification for the removal of judge. Remember, there is a act called as Judges Inquiry Act, whereby the detailed procedures about the removal of a judge are given in. Next is like Article 124 talks about the parliamentary power to actually regulate the procedure for removal, and on this basis the Judges Inquiry Act was actually been established. Then regulate the conditions for service, and the salaries, allowances, leave, pensions of the judges are determined. Here you need to find out, you need to understand that since the judges allowances and the remunerations of the Supreme Court judges are actually given in the second schedule, they are not varied to disadvantage. So that is a very crucial aspect of the independence of the judiciary that exists in. Next is Article 124, which is talk about like the salaries and allowances, and they are determined by the parliament as discussed in and also reflected in the second schedule. The major thing that I want you to remember is they are charged on Consolidated Fund of India, which means that they cannot be subject to vote, they can only be discussed, but they are already charged on Consolidated Fund of India. It means their expenses from the Consolidated Fund of India are actually mandated. Next is Article 126, which talks about the acting Chief Justice of India, which is like a temporary arrangement when current Chief Justice of India is unable to like discharge his duties, then President may appoint the senior most of judge as a acting Chief Justice of India. One thing I want to highlight here again is after the second judge's case, the President's discretion with respect to the appointment of CJI, not acting, but the permanent CJI, appointment of CJI has been done away. Now, only senior most judge of Supreme Court can become a CJI. Next, they talk about the ad hoc judges. What are ad hoc judges? When there is a lack of quorum, when the number of puissant judges which was like granted by the parliament, but the number exists beyond a certain limit, then what the Chief Justice of India does? Chief Justice of India, after consultation and the consent of the president, can ask judges of High Court to act as a ad hoc judges of Supreme Court to ensure that like there is smooth functioning, there is a lack of delay of the procedures, cases, discussions, and so on. And in addition to like the judges of High Court, CGI can also call for the retired Supreme Court judges to come in and discharge a bit of duties, so that like they can actually handle extra workload or handle the cases where there is a lack of quorum. Then next most important article with respect to it is Article 129, which talks about two things. Very important article. This has been asked in prelims almost like 3-4 times in past 10 years. First is it makes Supreme Court act as a court of records. What does court of record mean? It means that like all the pronouncement, all the proceedings, all the judgments of Supreme Court are actually stored for the eternity, and they are recorded for the eternity. Secondly, they have evidentiary value. It means like the judges of Supreme Court cannot be questioned in any other court. And most importantly, it means that they are actually recognized as something which is like a law or legal practice. Next is like power to punish the contempt for it. So the power to punish for the contempt of not only itself but other courts is also been given in under Article 129, and the power to punish for its contempt can also be a civil power, and and there is also like criminal contempt of court as well. And this has been like procedurally clarified in Contempt of Court Act, which actually bifurcates the division into civil contempt, criminal contempt, and defines what kind of criminal what kind of like contempt is existent, what are its provisions. But though it's like very loosely defined, and actual what the contempt is not like very clarified in the article or the act also, but the power is very crucial to the independence of the judiciary. Next is Article 130, which talks about the seat of Supreme Court. Constitution itself declares New Delhi as the seat of Supreme Court. However, CGI with consultation of President can actually appoint any other place. Again, this is a very crucial article. Many of the state TCS exams ask this article. Then very important article is related to 131, which talks about the original jurisdiction. What does original jurisdiction means? Here, it's not only original but also exclusive. Original jurisdiction means that the ability of Supreme Court to hear the matter at the first instance. So aggrieved parties can directly approach the Supreme Court. Direct approach is there, and it does not necessarily mean by the way of appeal. Exclusive means that only Supreme Court has power. Only Supreme Court has power to hear these cases. And under Article 131, original and exclusive jurisdiction of Supreme Court is actually established for the federal character of India, which is reflective of Article 1. And here, the disputes between the center and the state and the state of the federal nature only, and where only legal right of propriety is in dispute, then only like the matter goes to the Supreme Court. And remember, here only federal units must exist. So a union territory and a center cannot like go under to the Supreme Court under Article 131, because that won't constitute a federal linkages. But state versus state, and a few states versus a center, or few states and center versus a state, they can like all the possible combination would take you there. This is again a very central article, very central aspect, and will exist in there. Next, they talk about Article 132, 133, 134, 134A, and then 136. These articles talk about the appellate jurisdiction of Supreme Court. Here, appellate jurisdiction can actually be constituted under four heads. First is like the constitutional appeals. So, if let's say there are certain matters where substantial question of law or substantial interpretation of constitution is in discussion, then the Supreme Court, by its power as a final arbitrator and interpreter of constitution, would actually clarify the question. Next would be like the civil appeal, and the next would be like criminal appeal. In both the cases, the civil appeal and criminal appeal, the appeals from the judgments of High Court are actually laid before the Supreme Court, where they feel that a substantial clarification over a law or a fact is required. Then only then the High Court would certify such fitness, such appeal for the fitness of it, and then that would lie with the Supreme Court. The third and the most extraordinary, fourth and the most extraordinary power with is like the special leave petition. Special leave petition is probably the most discretionary, most extraordinary power that exists with the Supreme Court of India. It says that Supreme Court has special leave to grant appeal against any court, any matter, any tribunal in the territory of India. So it's actually a power to hear any matter from any court, whether it's like a final judgment, whether it's an interlocutory judgment, or whether like it exists in the in some other form. In every case, Supreme Court has power to hear appeals from that judgment and take the case before it. Remember, it's a discretionary power and it's an extraordinary power. It's the widest appellate power, and the appeal from case pending before any court or any tribunal can actually be put in. However, like there is a exception whereby the court martials are actually cannot be like brought into Supreme Court, because it's obvious it's matter related to military. But rest of the other cases, every appeal can put in place with the Supreme Court. Supreme Court uses this article and Article 142 to bring in extraordinary justice to the citizens of India, which is actually like its mandate. Supreme Court of India is entrusted with the power and with the authority to actually be guardian of the fundamental rights and also custodian of the Constitution. So in both of the cases, these articles would actually make Supreme Court like one of the most powerful court of Supreme Court of the any Supreme Court that exists across the world. Next is the review power of the Supreme Court. So Supreme Court has a revisionary power. It can overturn its earlier judgments and then make the law evolutionary or dynamic. This is very particularly important with respect to like the evolution of the basic structure which took place. Evolution of basic structure, where you would be knowing that there was the Shankari Prasad case where they discussed about whether Article 13 is a whether Article 13 and the definition of law includes Constitutional Amendment Act or not. Then there was this Shankari, there was this Golaknath case, there was Keshwananda Bharati case, there was Minerva Mills case, and you would be knowing all of it. The power to review judgments are very central, and it actually can be read with Supreme Court being court of records. Next is Article 138, which says that Parliament can actually expand the jurisdiction of the Supreme Court, though it cannot curtail it. Remember, Parliament can only expand the jurisdiction of Supreme Court, but it cannot curtail it. And also, like the Parliament can also expand the writ jurisdiction also under Article 32 and empower any other court with respect to writ jurisdiction. However, this article should also be read with Article 138, ensuring that it should not be like in with the lowering or curtailing the writ jurisdiction of the Supreme Court of India. Then, like this, again reflected in the discussion which I talked about, is again reflected in Article 139. Then the article 140, 141, they are other articles which are actually like meant to supplement the jurisdiction power, the enforcement of the provisions of the Supreme Court. First is like article 141 says that laws declared by Supreme Court are binding on all courts, and it ensures that there is a doctrine of precedent for all the courts with respect to the judgments, proceedings, and laws and declarations which are made by the Supreme Court. So again, this would be like read with the court of record provision, and the evidentiary value or the highest judicial authority of the Supreme Court in the integrated judiciary can also be established from it. Next is very important articles, which is like article 142, whereby there is a mandate to the Supreme Court that it can actually bring in complete justice to the people of India or the subjects of India, and here they can pass any decree, any order like to bring in the complete justice, and all the authorities of the government, all the authorities of the state would actually aid and supplement and give effect to the directions which are made by the Supreme Court. So this is very extraordinary, very comprehensive power, and these powers like article 142 and 136 together they make Supreme Court a guardian of the fundamental rights. They make guardian of the justice in territory of India. Next important article is article 142, which talks about the advisory jurisdiction. Here president may seek opinion from the Supreme Court on such matters which he feels like he or she needs a bit of clarity. And remember, they are not judicial pronouncements. So you shouldn't say that like they are in line with the article 141 or article 139, whereby like the laws binding by the Supreme Court are laws made by the Supreme Court, or the pronouncements made by Supreme Court are binding. They are not of that nature. The article itself mentioned that it's an advisory jurisdiction. They are advice given under the article 142 is not a judicial pronouncement, and president can actually like seek opinion from time to time. There is a bit nuance to it as well, like those matters which are like related to pre-constitutional decree or the pre-constitutional agreement. Supreme Court must give advice to the president. However, for such others matters where Supreme Court doesn't feel like giving advice in, they can actually do not give advice as well. So so it works both ways. The advice given by the Supreme Court to the president is not binding on him, and also the mandate to give advice for the Supreme Court is also not binding until like it's a matter related to pre-constitutional agreement or decree. Here again, article 144 to ensure that there is a supplementary provision whereby all the authorities of the state are there, must be put in to assist the Supreme Court, to assist the orders, to assist the bringing in justice, values, procedures of the Supreme Court, everything. And next, like a minor article which exists in, which is article 147, which says that for the purpose of Supreme Court jurisdiction, what laws exist in. So they actually means that it applies to article 124 to 147, and it includes pre-constitutional laws and laws made by the parliament. So this is again not a very significant article, but again something which you need to be considerate of. And then there is another article 145 which talks about the ability of Supreme Court to make rules, procedures for its own functioning. So Supreme Court has power to actually regulate itself, and this actually is a very crucial for the independence of it, and ensures that like the functioning is very smooth, and the ability of Supreme Court to be at the highest pedestal in the eyes of citizens of India is actually like maintained. Then a bit of clarifications with respect to like the contempt of court, because this has been asked 2 times in the prelims. So Article 129 talks about the contempt of court of the Supreme Court, and also like the similar provisions are reflected in Article 215 as well. And for the procedural clarification, so laws are of 2 types, which are one are of substantive law and then other are procedural law. The procedural law actually aid the substantive law in clarification, in determining the procedures that exist in. So to actually like clarify and make functioning smooth, Contempt of Court Act was put in 1971, and it categorizes contempt of court in 2 factors. One is civil contempt, whereby the willful disobedience of the court orders, decrees, or judgment is put in. Uh, Here, majorly, it's like a non-compliance, and you can remember it from the fact that civil and disobedience. So, civil disobedience would actually be like a trick that you can think of. Then there can also be criminal contempt of court, which seeks to scandalizes the authority of the court. It lowers the authority of court, and it actually, if a person acts in prejudice to the judicial proceedings, then it would amount to criminal contempt, and such thing would actually come into the criminal aspects of the contempt of court. I hope like this 15-minute discussion would be extremely helpful for you. Revisit it again and again, learn all the provisions, learn all the minute details with respect to these like 20 articles. Trust me, they are going to help you not only in prelims but also in mains. If you wish to like need such more clarity with respect to other areas of the prelims and polity as well, or the other subjects, you can actually check out our initiative at SkeletonKey by nurturing for UPSC. Till then, Jai Hind and all the best.